Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, good morning. We're back on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access to our civil docket, both in the courtroom and also online. And our next case is Beerline Companies, LLC versus Ham Paper, LLC, file 24-9065CB. Counsel, you want to state your appearances, beginning with plaintiff?
Good morning, Your Honor. David Pushkar on behalf of the plaintiff, Beerline Companies.
Good morning, Your Honor. Francis Belzer Wilson on behalf of defendant Ham Paper 11 LLC.
And I can also tell the court, Mr. Fleming, who there is my client representative. So he's calling you to observe. Yep.
All right. All right. This is defendant Ham Paper's motion for summary disposition under C10. And I've read the motion, the response, the reply, and the attachments, and you both have done an excellent job preparing me for the law and the factual issues at issue here. So I appreciate that. Go ahead, Ms. Wilson, with any argument you wish to make.
Thank you, Your Honor. I'll try not to belabor any of the points. It's clear the court is prepared. But just as a brief overview, hopefully, this is a case where the plaintiff has filed a 2-count complaint against Great Lakes Tissue Company, for which they have a default, and against my client, Ham Paper 11 LLC. And turning first to the breach of contract claim, Your Honor. The contract at issue is located as Exhibit 5 of the brief. It's a 2-page contract. It's undisputed that the contract was prepared by plaintiff, and that at the time it was prepared, and at every time after, all parties to the contract itself believed that the contract was between Beerline, the plaintiff, and Great Lakes Tissue Company, the defendant. The contract was signed by Great Lakes Tissue Company by a Julie LaFond. In the briefing, Your Honor, I just point out she now goes by a different name. I believe it's her married name, so which is Caligari. She testified that she was an employee of Great Lakes Tissue Company, and that she was not an employee or agent of Ham Paper 11, which is confirmed by Mr. Hamco's affidavit and testimony, Mr. Hamco being a member and manager of Ham Paper 11. Interestingly, the plaintiff seems to want to rely on its own inaccuracies in its 2-page contract here that it drafted, and somehow foist some type of liability onto my client because they, being Beerline, defined Great Lakes Tissue Company as an owner. Just because they didn't do any due diligence. That's also supported by the record, Mr. Cornell. Mr. Passiano, and I apologize if I said his name incorrectly, his deposition testimony is cited. He was dealing with Julie LaFond in regards to this. At no time did she represented anybody or was acting on behalf of anybody other than Great Lakes Tissue. And she signed this document in her capacity for Great Lakes Tissue Company. So, Your Honor, the contract at issue is in no way does it indicate that it's with Ham Paper. Ham Paper didn't sign it. It didn't authorize it. It actually had no knowledge that this contract was being signed, which is all supported by the testimony. I think that within this contract that Beerline prepared, it just defines Great Lakes Tissue Company as an owner. In no place does it represent that it is actually an owner. And I mean, they could have chosen any title to put after Great Lakes Tissue Company. They could have put astronaut. I assure you, Judge, it would not make Julie LaFond an astronaut. Just because Beerline has an inaccuracy in their definition of who Great Lakes is does not somehow make Hom Paper a party to this contract, nor does it create some type of agency, as plaintiff's counsel has brought up in their response brief. No one thought that Great Lakes Tissue Company was acting on behalf of Hom. Julie LaFond, who signed this, did not believe she was acting on behalf of Hom. And at no point in time did Hom authorize Great Lakes or Julie LaFond to act on its behalf. And the lease that plaintiff's counsel looks at in its response expressly states at section 26.3, I believe it is, that there is no agency relationship. So that takes us past the breach of contract argument, Your Honor. My client, Hom Paper 11, is not a party to this contract. Next, we go to your unjust enrichment argument, Your Honor, which, as I'm sure this court is well aware, where there's an express contract between two parties, the contract governs. Only in instances where there's been some misrepresentation or fraud or some type of wrongdoing by a third party that potentially benefits from other parties' contract, can the non-party to the contract be held liable? And that is well established in our courts under the Morris Pumps and its progeny, Your Honor. I'll cite it in the briefing. And here, there's no question. There's no issue of fact. Hom Paper didn't know this contract was executed. It didn't know it was being performed. It in no way requested the services. It is clear from the deposition of the 5 plaintiff representatives, being Mr. Fleming, Mr. Pisano, Mr. Cornell, Mr. Farver, and even a Miss Forrest. They had never heard of Hom. Nobody represented to them in their dealings that individual was working on behalf of Hom. Hom had no idea this was going on until after the fact. So under the case law that's cited, being Morris Pumps, its progeny, Landstar, my client, Hom Paper, did not request the services. It didn't mislead anybody about the services. Therefore, there can be no unjust enrichment claim. Turning quickly then.
What am I to make of the plaintiff's response that, I mean, although they don't expressly concede anything, the tenor of their response seems to be putting the eggs in the unjust enrichment basket more than the contract claim, which I think is admittedly the weaker. But what am I to make in the context of an unjust enrichment claim of the fact that your client was in fact enriched? The question is whether that's unjust to allow them to retain that benefit without paying for it when there's the web of ownership interests that the plaintiff has alleged. What's your response to that?
Sure, Your Honor, and that was the point I was just going to turn to. That's this interconnectedness argument that counsel raises for the very first time in its response brief months after the close of discovery. What this is a disguised breach of, a disguised piercing the corporate veil or alter ego theory. And as I'm sure Your Honor is well aware, the courts are reluctant to disregard separate entities when formalities have been followed. Now, here, or I should say in instances where the courts are willing to look at that, that's for situations where an owner or somebody within, the line of ownership has somehow perpetrated a fraud or a wrongdoing. Here, Hom Paper has no ownership in Great Lakes Tissue. This is not a viable legal argument for counsel. Moreover, the courts have held, and I'll cite the Glenn factors. There's about four of them, Your Honor. I'm sorry, maybe there's 5 of them. Let me turn to that, please. Allegations or evidence of undercapitalization, that separate books were not kept, separate finances were not kept, that a corporation was used for a fraud or an illegality, the corporate formalities were not followed, and whether a corporation is a sham. None of that has been established in this case, Your Honor. We are past the point of discovery. This is a wholly inappropriate argument by counsel at the last minute. However, I don't think that it holds any weight. I think it's flawed because it's meant to pierce ownership vows. And we don't have that here, Your Honor. The alleged manipulation has nothing to do with the contract at issue. And they're actually going against, they rely on Mr. Homko. They haven't, he's not even a party to this case. Patriot Advanced Technology is not a party to this case. Ramjet, which they refer to, not a party to this case. Mr. Homko, not a party to this case. So, Your Honor, I don't think that there's been any type of manipulation that's been shown. How could there be when Mr. Homko for Hom Paper didn't know anything about the contract? That being said, I think that this is a piercing the corporate veil argument, and it's wholly inappropriate at this point, and it should be disregarded. And finally, it's fatally flawed. If you have any other questions, I'm happy to answer them, Judge.
Okay, thank you. Mr. Pushkar, go ahead with your response.
Thank you, Your Honor. Would you prefer I address the court from the table or the?
Whichever you feel more comfortable with, that's fine.
Thank you. Your Honor, this is a particularly unusual collection case because there's no assertion here that airline companies did anything wrong, didn't do the work correctly. And there's no assertion here that the property didn't obtain a tangible benefit from the work that was done. There were mounds of what's called polymaterial, which I understand to be a byproduct of the paper process. That product was contaminated with asbestos when the roof collapsed. Now, we're here on summary disposition, and the facts are supposed to be viewed in the light most favorable to plaintiff. If you take a look at our statement of facts, and as we kind of go through the background here, Mr. Kip Boy, who was the key person involved in all of this, testified that Hom Paper knew about the issues with the roof, okay, in advance of this contract coming into place. So we have that knowledge going in. We have a lease, and the lease has a number of different terms in it: repair, maintenance, keep the property safe, keep it upkept. Your Honor notes that, when looking at the two claims, which one would be the strongest, breach of contract or unjust enrichment? I agree that the unjust enrichment claim is strongest. I actually think it's quite strong because you don't need to get into this fraud or misleading argument at all. That's a misstatement of what the law is. What the law is was that service requested? Was it requested? The lease doesn't just request it, it requires it. Now, counsel makes, and I would do the same, makes the argument that Hom Paper didn't know of Beerline. Beerline didn't know of Hom Paper. Fair enough. But Hom Paper certainly knew and certainly authorized its tenant to go out and find people to repair, maintain, keep the property safe, keep it in good condition.
Well, sure, but doesn't that by its terms then say that's the tenant's obligation to make that happen? Why would that then, if a landlord says, hey, tenant, I want you to keep the property in good repair, that's not the same as the landlord saying, and I'll be on the hook for the cost of it.
Well, but in that circumstance, Your Honor, the landlord most certainly knows that it's going to obtain a benefit from that work, right? And so, no, there's not in that scenario, a direct contractual relationship between Hom Paper and Beerline, although I'm arguing about that through another means. There is an understanding that, tenant, when you go out and do that work is going to come back for the benefit of my property. It's a request to have that happen.
Okay, so you're saying that term in the lease satisfies, at least implicitly, the requirement for the third party to have requested the benefit to pursue an unjust enrichment claim. There's a contract between the other two parties.
Absolutely. So in that scenario, it would be the unjust enrichment claim, not the breach of contract claim. I certainly agree that when there is an express contract, the terms of that contract govern between the parties. And that's why this particular case is explicitly pled in the alternative with these two counts. In terms of going through kind of and I want to make clear when you take a look at that, it's not it's not a must request, and there must be some kind of misleading of the corporate form or some kind of fraud or something like that. It's not an and, it's an or. If there's a request for those types of services and those services are performed and they benefit, which they clearly do, that's not even really in dispute in this motion. That's enough for liability on that count. We have presented, Your Honor, with probably too many, but some charts and tables and things like this, which go through the corporate formalities issues with respect to these entities. The thing that I want to point out for Your Honor on this is Mr. Homko is on both sides of these transactions, and he is all the way through. Well, when I got the reply brief this past week, one thing that I noted immediately was there were at least 3 new pieces of evidence coming in the reply brief that were not in the original briefing. We have Mr. Homko's affidavit, and we have an affidavit from a deceased individual who indicates that he is actually the board chair of Patriot. What's important to note about that is that that affidavit post dates all the work done by Beerline. Okay. What the evidence viewed in the light most favorable to my client is that Mr. Homko was directly involved with all these entities at all relevant times. And I think when you couple that with Mr. Boyd's testimony that that Hom Paper knew of these issues with the roof, and that it makes certainly viewing the evidence in the light most favorable to us creates an issue of fact, I think, on that point. In terms of this issue of the alter ego theory not being proper, I have a few cases here, Your Honor, that go through, and this is something raised in the reply brief, that go through what that theory is. It's not a claim. It's not we wouldn't have in our complaint count 3 alter ego. The case law is very, very clear on that. What happened here is that throughout the course of...
Well, I mean, I agree with you on that, that you don't need to have a count 3 to get there. But I wonder on the substance of it, though, all that would allow you to do is sort of pierce through these entities from Great Lakes Tissue to its owner, Patriot Advanced, or any of those owners, which include Ramjet. But that still doesn't get you to proving that Great Lakes Tissue was nothing more than an instrumentality of Hom Paper. So I'm not seeing enough of the connection there other than just a landlord tenant.
Understand that the other thing I would ask the court to keep in mind, though, is that Hom Paper acquired the property through something called Hom Properties, which got the property from Great Lakes Tissue at the same time as all these ownership transactions were happening. So it's not just the lease component that ties these together, it's the transfer of the real estate as well. Then coupled with the fact that all of those entities don't have many records. And we went through all of that with Mr. Homko in his deposition testimony.
Well, I mean, when we're looking at, though, the unjust enrichment claim, I mean, you have a contract with Great Lakes Tissue that they didn't pay the bill. You've got a default against them. I mean, honestly, if they were a collectible entity, you wouldn't even be going after Hom Paper. So I'm having a hard time getting to unjust enrichment against Hom Paper when your client has a contract, has a debtor, you can obtain a judgment against that debtor. Your client, before doing a several $100,000 contract, could have and did not seek a personal guarantee. And so now we're just going to reach out and grab who we can find. Let's grab the landlord and let's try to make them liable for this bill. If there's an unpaid bill, the law's got to ask who should be stuck with that bill, the landlord or the one that did the contract. I grant you, the landlord obtained a benefit. So there's some argument there. But between the 2 people, where would the law justly place this risk of loss? Wouldn't it be on the party that, contracted and didn't get a personal guarantee, and you can get a judgment against the party you contracted with? But why should the landlord be on the hook?
My pushback to you there, Your Honor, would be that reasoning would allow a landlord who knows it's going to obtain a benefit to contract all risk of that issue away from itself. through the tenant. And I don't think that's what the law allows here. If you take a look at that express language in the lease, and then you compare that to what the law of unjust enrichment is, I think those things match up. And I think certainly on summary disposition, they require that claim to make it through, the unjust enrichment claim.
Okay. All right, thank you. Anything else I need to know to understand your position?
No, Your Honor, thank you.
All right, thank you. Ms. Wilson, any response to that rebuttal?
Briefly, Your Honor, thank you.
I
In
guess
regards
I'm particularly interested in your answer to this question then. It seems to me the best foothold the plaintiff has, as I see it, is does this lease, by telling Great Lakes Tissue to keep the property in repair, does that, under these facts, constitute an implicit request for the benefit that would trigger that would satisfy that Morris Pumps case?
No, Your Honor, and I think that can be further seen through some of the other cases that I cited, particularly the I believe it's the Landstar case. In that case, essentially what the courts recognize is just because somebody has an underlying contractual obligation to do something, that is where the burden is put. So for what I mean by that, Your Honor, is Hom Paper and Great Lakes delineated their duties. This is Great Lakes' duty to keep this clean, safe, repaired, whatever the language is in the lease. And that's where the burden is placed. There's nothing additional. That is exactly what the Hom Paper and the tenant contracted for. And a third party cannot come in and reach a landlord, an unknowing landlord who didn't know about these contracts, didn't agree to anything. The case cited by plaintiff's counsel, the Rowan case, related to this issue, is very factually and legally different. That was a construction lien case, and in that instance, that landlord was actually paying tenant improvement funds to the contractor doing the work. So, Your Honor, I don't believe that you can go outside the contractual bargain for benefit between these various parties. And, you know, to the counsel's point about new evidence being set forth in the reply brief, we've never once heard a piercing the corporate veil claim or an alter ego claim. Mr. Swenson filed that declaration in a federal lawsuit that plaintiff's counsel was well aware of because they used exhibits from the exact same case in the deposition. So we know that as of at least April, that Mr. Swenson was the chairman for Patriot. And that corroborates Mr. Homko's testimony that was given. So those would be my responses, Your Honor. I think the Landstar versus Next Year and Morris Pumps fully supports Hom Paper's position. There can be no unjust enrichment. There has to be some wrongdoing.
All right, thank you. Well, in this case, there's a claim brought by plaintiff against this defendant for breach of contract and unjust enrichment. In January of 2023, plaintiff entered into a contract with Great Lakes Tissue to remove paper byproduct material, which included asbestos contaminated material from a damaged roof. Great Lakes was a tenant of the property under a lease. The actual property owner and the landlord of that lease was the defendant, Hom Paper. There's no dispute that the plaintiff did the work under the contract. There's no claim that that work was unsatisfactory in any way or incomplete. They submitted an invoice to Great Lakes Tissue for $343,000 and some change, and Great Lakes refused to pay it. They've been named as a defendant in the suit for a breach of contract and well, I think in the unjust on both counts, and they've been defaulted. The plaintiffs can seek a judgment if they want. The plaintiff then demanded payment from the landlord Hom, which also refused to pay, bringing forth this lawsuit. Defendant Hom moved for summary disposition under C8 at the start of the case, and I denied that motion, saying that the plaintiff should at least be allowed to go through discovery to see whether any of these folks were acting as a representative of both companies to support the breach of contract claim, and that the unjust enrichment claim really depended on a lot of factual development. So I denied that motion under C8, allowed the case to proceed to discovery. Now, at the close of discovery, Hom Paper renews a motion for summary disposition, bringing it under C10, alleging that there's no real genuine issue of material fact and that they're entitled to judgment as a matter of law. On the breach of contract claim, I certainly agree with that. Here we have an express contract. It's between the plaintiff and Great Lakes Tissue Company and not Hom. There's no evidence of any contract with Hom. There's no evidence of any contact between the plaintiff and Hom. There's the discovery showed that the representatives that plaintiff were dealing with were representatives of Great Lakes Tissue Company only, and not also representatives of Hom Paper, and that they did not hold themselves out to be such. So therefore, there's really no genuine issue of material fact on the breach of contract claim. And under those undisputed facts, defendant Hom Paper would be entitled to judgment as a matter of law on that claim. Then that brings us to the unjust enrichment claim. Hom Paper says that there's no unjust enrichment because Hom did not request plaintiff services, did not mislead anybody, had no communication with them, relying on the Morris Pumps case 273 Mishap 187 at 196. Quoting the Amjur on restitution and applied contracts, stating as follows, quote, "A third party is not unjustly enriched when it receives a benefit from a contract between two other parties, where the party benefited has not requested the benefit or misled the other parties." And so Hom Paper says, well, we didn't request this benefit. We haven't misled anybody. So it's not unjust for us to have received a benefit by virtue of this contract. Plaintiff's response is really not so much that there was a misleading, but that there was a request for the benefit by way of this lease. The lease between Great Lakes and Hom Paper required Great Lakes to keep the property in good repair. This might well mean that it does mean that Great Lakes was authorized to enter into that contract. But I think that plaintiff interprets that lease too broadly to say that that is a request for the services, even implicitly. I mean, perhaps Hom Paper would have contracted with a different party under different terms, under different timeline or different method of services or payment, or I have no idea. But just because a tenant has engaged a contract for services doesn't obligate the landlord, absent the landlord, really being the one behind the scenes saying, we want this done, this specific service. So there's no evidence here that Hom Paper has requested that this byproduct, including the asbestos, be removed by beer lane companies pursuant to this contract. So for that reason, there's really no genuine issue of material fact on that as well. And the defendant, Hom Paper, would be entitled to judgment as a matter of law on that claim. Beer lane says that, well, there's a complex corporate ownership showing interconnections between Great Lakes and Hom, so that Hom shouldn't be allowed to avoid liability. Great Lakes is owned by Patriot. Thomas Homco was at some point at least chairman of that board. He's also a member of Ramjet, which is one of the member companies of Patriot. And of course, Homco is a member of Hom Paper. But in this case, these theories rely on sort of piercing the corporate veil or alter ego theory. But the plaintiff just sort of throws that out there, showing that there's a web of ownership interests that falls far short of piercing any of these corporate entities. There's no evidence that Great Lakes Tissue was a mere instrumentality of Hom Paper. even if you were to somehow pierce those corporate entities, that would get you to Patriot Group. There's no real evidence that connects the landlord and tenant such that would obligate the landlord here under that lease or under that contract. So there's really no genuine issues of material fact that would require a trial in this case. The question really comes down to the breach of contract. I think clearly the defendant wins. And on the unjust enrichment, it really comes down to, does this lease requiring the tenant to keep the property in reasonable repair constitute an implicit request for these services? We don't need a trial to do that. There's no question of fact here. It's just how you interpret that. And, I believe that that's too broad of an interpretation of that. There's no evidence that Hom Paper specifically requested these services or that they misled anybody, so that therefore they're entitled to judgment as a matter of law. So I'm going to grant the motion in full of Hom Paper entitled to summary disposition under 2.116C10. The plaintiff holds a default against Great Lakes. They can notice up a motion for entry of default judgment if they wish. In fact, we'd really need to get there to get to a final judgment for you to pursue appellate review of my decision. But I would grant the motion, and Ms. Wilson, you can submit an order to that effect. All right, thank you all very much.
Thank you, Your Honor.
Thank you for your time, Judge.